Good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada, and we're looking forward to hearing your testimony today.
Good afternoon from Oregon. I'm Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's intermediate appellate court.
And good afternoon. My name is Steve Jewett. I'm a county court judge in Orange County, Florida, in the 9th Judicial Circuit, which is Orlando.
And please introduce yourselves.
Hi, I'm Wadra Hall, and I've been accepted into Cornell and pursuing my career in architecture.
Hi, I'm Sam Stockfish. I will be joining GCU's Barnabas Pastoral Program while I study for my bachelor's in Christian Studies and my master's of divinity.
Hi, I'm Haley Howerton. I've been playing the trumpet at a mediocre level for about 9 years. Our coaches are Miss Lindblom and Miss Litzenberger.
So the question today is for Unit 5 is question number 2. And this is a quote from Thomas Jefferson. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? In addition, what are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
Among the beloved Schoolhouse Rock videos is No More Kings. King George III declares, anything I say, do it my way. Don't you get to feeling independent because I'm going to force you to obey.
Perhaps this mentality is why a Bill of Rights is needed, something that the people are entitled to against every government, according to Thomas Jefferson, establishing that on a national and state level, government derives its power from the people in exchange for protecting their rights.
The U.S. Constitution did not prioritize the protection of natural rights when initially drafted, and it should have. The major premise of a constitution should be the delineation of the rights of the people. Brutus II predicted that rulers are likely to use the power to injure and oppress those over whom they are placed, and a Bill of Rights will protect the people from the government by setting limits on their powers. For example, the 6th Amendment's trial protection and the 8th Amendment's protection against cruel and unusual punishment.
In addition, the protections of speech, press, assembly, and petition in the First Amendment have been historically used to expand rights, notably resulting in the passage of the 15th, 19th, and 26th Amendments, the Civil Rights Act of 1964, and the Voting Rights Act of 1965.
Where the U.S. Constitution did not initially prioritize a Bill of Rights, more recent international constitutions do. For example, the 1996 South African Constitution includes a Bill of Rights in the 2nd chapter as its major premise. Similarly, the Arizona Constitution includes a Declaration of Rights in the 2nd article.
Interestingly, during the 1787 constitutional ratification debates, the Federalists believed a national Bill of Rights was unnecessary, but we argue advantages of a national and state Bill of Rights make them both necessary.
The National Bill of Rights establishes a standard set of liberties protected by the federal government, even when a state government is the one abusing those rights. According to Jeffrey Rosen, the former acting attorney general, through the 14th Amendment's incorporation, the Bill of Rights became a document that defends minorities against overreaching state governments.
For example, 1967 Loving v. Virginia held state laws against interracial marriage unconstitutional, upholding equal protection under the 14th Amendment. 1986 Baston v. Kentucky held racial discrimination in state juries unconstitutional, upholding the 6th Amendment.
State Bill of Rights offer protections not in the National Bill of Rights and can be tailored to their regions. For example, Arizona protects industrial pursuits, Pennsylvania protects natural resources, and Utah protects customer water supply. Additionally, state amendments do not have the same high threshold as Article 5. Thus, rights are easier to expand in the states. In 1972, Washington added protection of gender equality.
A combination of both national and state bills of rights mitigates the disadvantage of the state bills of rights only applying to a single state, and the U.S. Bill of Rights infringing on federalism.
Negative rights called liberties obligate an action requiring fundamental rights to be respected and left alone. Some negative rights include the First Amendment's freedom of religion, the Second Amendment's right to bear arms, and the Fourth Amendment's no legal search and seizure.
In contrast, positive rights or affirmative rights require a duty to provide or act in a certain way. Some positive rights include the right to a job, healthcare, and education.
Judge Richard Posner explained the men who wrote the Bill of Rights were not concerned that the government might do too little for the people, but that it might do too much to them. So they focused on negative rights as the most essential protection of liberty.
For example, 1964, Map v. Ohio held that evidence illegally obtained cannot be used in court justified through the Fourth Amendment protections. 1971, New York Times v. US held that prior restraint preventing the New York Times from publishing the Pentagon Papers was unjustified under the fundamental law embodied in the First Amendment.
By the end of No More Kings, the people are crying out, over the horizons, what can it be? Looks like it's going to be a free country. True to these lyrics, the Bill of Rights in the US Constitution and state constitutions have worked together to secure the rights of the people.
What, if any, what limits, if any, should be placed on rights listed in the Bill of Rights?
I don't think that, oh, go ahead.
Go ahead, Juan.
Okay. I don't think that there should be any limits placed into the rights of the into the Bill of Rights, because almost most rights placed in there are essential. In our Bill of Rights, we grant the first 10 amendments, which are the fundamental rights that are necessary, but we should also include positive rights that would help ensure that the government is doing its best for the people, since the government derives its power from the people. And such positive rights include, let's say, the right to a job. And coming from a family of immigrants, I understand that many immigrants face many difficulties finding a job because of the language barrier. And so implementing a job guarantee would ensure that those people have the accessibility to live a proper life in the United States. And even the UN enshrines full employment in Article 23, saying that it has an essential link with the maintenance of human rights. So any right is essentially just fundamental.
Go right ahead, Haley.
I would also add that any right that is added in the name of protecting a liberty, however, discriminates against another group, should not be added. For example, in Colorado's Article 1 Bill of Rights, they have Section 30B, which states that there are no protections for anyone in the LGBTQ community, which directly goes against the idea of a Bill of Rights protecting the people.
I would say that there should be some limitations on certain rights. For example, one's free exercise of religion when it comes into conflict with other people's beliefs or lifestyles. For example, in 2006, Harper v. Poway Independent School District, we see that school district actually punished a student for wearing anti-gay religious messages on his shirt. And the Supreme Court was called in to see if this was a violation of his free exercise. And they found that was not a violation of his free exercise, and actually was constitutional, given the fact that the school was doing this in order to maintain the equal protection clause for LGBTQ students. So we see that there should be certain regulations on rights in the Bill of Rights throughout.
What is the difference, if any, between rights added through the amendment process and rights that are developed through court decisions?
The immediate thing that comes to my mind is speed. The last amendment, the 27th Amendment, was passed 1992, almost 30 years ago, while February of this year, the House recently passed the Equality Act, which guarantees protection of gender and LGBTQ groups. I would argue that this is why we tend to use legislative acts and adding on to existing rights, such as in Griswold v. Connecticut, where we added a right to privacy, rather than actually amending the Constitution itself.
It's also important to note that especially with state constitutions, there's different ways to actually amend amendments. For instance, in Arizona, we have the initiative process in which we actually got to pass Proposition 208, which funded education by increasing taxes on the wealthy. And therefore, we were able to provide a more quicker and easier way to actually guarantee certain rights to the people.
Well, and that brings up an interesting question. Is that I hear what you're saying, that it's a good thing, but can you see a downside to having that ease of amendment, making it that nimble?
It would create an imbalance of power. If the government itself was to decide that they wish to pass a harmful amendment, they could do so.
I think overall, we have to recognize that with an easier amendment process, we need to have this idea that times change and people will come in and go within our government and within our authorities, and they will have different ideas. And we need to ensure that as we promote more and more rights and open up more and more opportunities for LGBTQ minorities and so forth, we need to be able to change our amendments given those situations. So when we have this very, very strict amendment process that we have in Article 5, we need to recognize that that's going to cause some issues with how fast we can move forward with the times.
I would actually have to say that having an easier amendment process helps to actually adapt to certain times and certain cultures of different regions in our country. For instance, in Texas, under Article 33 and 34, they have the right to use public beaches and hunt, which just shows that this right in their Bill of Rights is specific to the customs and culture of Texas itself. While in Alaska, they provide the residents with the ability to give them job preferences. And so with this, we see that different states and different regions have their own culture, and being able to actually have an easier amendment process that changes throughout time and to adapt to their culture and regions is very important to maintain the people's ability to choose what they want and the rights that they want.
What circumstances, if any, would cause a person to lose rights found in the Bill of Rights?
Imprisonment under the federal prisons does cause you to lose rights. In some states, it specifically causes you to lose those even when you are released. Another would be conflicts of rights. In 1993, Church of Lukami Babaluai v. City of Hialeah, the state statute held that the church itself could not perform religious sacrifices against animals. And although it was overturned by the Supreme Court, this just is an example of courts using using amendments to restrict rights of people.
Also, there's the idea that if you exercising certain rights infringes upon or disrupts the general welfare and health, then that's when the courts and the government itself is able to put restrictions on it. For instance, the Brandenburg test, which limits speech if it incites unlawful or behavior. So in this case, we can see that people, if they use speech for a negative way in order to harm others, there are going to be limits on them.
You mentioned the decision Batson versus Kentucky in your prepared remarks. Do you think that decision went far enough in terms of eliminating unlawful discrimination in jury selection, or do you think additional measures should be taken?
I would say additional measures need to be taken because it protects on the federal level and state level. But I do believe we need to ensure that we are protecting the rights of all people, not just citizens. Our Constitution states we the people, not we the people who can afford a good lawyer, or we the people who look like us, or we the citizens, but everyone. So I believe that that decision in Batson v. Kentucky should ensure there should be more measures to ensure the protection of all people, regardless of their status and their ability to hold a trial.
Knew it was coming quick. I knew as soon as I said anything, then that she was gonna hold it up. So I was like, all right. I've had that happen to me a number of times. I'm always the one. Okay, I'll just jump right in. I thought that your prepared statement was really good. You guys went through the questions and answered what was in there, which of course cuts out some of the stuff that we usually ask preliminarily. So I did enjoy that. I did like your discussion of the state and state versus federal constitutions and Bill of Rights, because that's something that I'm really interested in. And generally, that's why my questions go towards that. So I did enjoy it. It's a really good job. Thank you.
I agree. So I love the Schoolhouse Rock reference as the product of exactly the generation that grew up watching it as Saturday morning cartoons. I learned
for them it's like a YouTube thing or something, but we actually saw that on Saturday morning in the commercials and the cartoons.
Right. It's why I actually know the preamble to the Constitution in the first place. And so I like that you framed it with that, and it made it a little fun. You also answered the question really well, and I also enjoyed your discussion of the relationship between the state constitution and federal constitutions. I thought your discussion in response to the question about and taking the amendment process versus court decision was good in assessing, the speed and, the sort of the way that the legislature can play a role. And, as you probably guessed, I was very interested to hear you mention the Batson decision, which was a, important decision. I can't say I've heard anybody else bring it into this question. And so that really demonstrates, I think, the breadth of the materials that you've explored for this.
Yeah, I agree with my co-judges. I thought your prepared remarks were very good. You covered everything. You thoroughly answered the questions from a historical aspect. And I too enjoyed Schoolhouse Rock because yes, I also grew up on that too. It made me smile, and I enjoyed your ending your remarks with another quote with the lyrics from a song. I thought that was kind of neat. Again, you included lots of evidence in both your prepared remarks and in your responses to our questions. And all of you participated. I thought you did good with that, jumping in, and we did hear some things, some new and different perspectives from you guys this afternoon, which was nice. It keeps it interesting. So I thought, well done, and good luck with the rest of the competition.
Good luck.